Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we will be continuing with the appointment and remuneration of managerial personnel, right? So far we have understood who the managerial personnels are, right? And we have seen a little bit more about the same topic. Today, after we have discussed about the appointment, we will be discussing about the remuneration, right? And specifically for remuneration, we will have to refer to Schedule 5. Yes. So most of you, whatever material you would be using for your examination, I have seen most of the people they skip Schedule 5. Right? In this chapter, they go ahead with section 198, 197, 199 and all those sections, right? But what they do is they miss the entire Schedule 5. But my dear friends, Schedule 5 is important on a practical aspect. You need to understand the calculation and the limits behind the remuneration that has been given or that has been decided to be given to the managerial personnel. So today we'll start with Schedule 5. So today we'll be taking up the part 1 of Schedule 5, and in the next lecture onwards we'll be taking up part 2 and part 3 as well, right? And once we are clear with the Schedule 5, you will be crystal clear with how the remunerations are fixed in different companies and in different situations for the managerial personnel, right? And then we'll move on to section 197 where we'll be understanding the other details and the limits as well. So when we'll be going to section 197, there we'll understand managerial remuneration as the core of it. But there are situations where the limits and everything has been granted in Schedule 5. So today we'll pick up Schedule 5. So as per Schedule 5, when we see the eligibility requirement for appointment as a managerial person, so Schedule 5, it is something that gives the core of the entire remuneration and appointment. Because if there is a deviation from this, you go ahead with the central government. Otherwise, if Schedule 5 is satisfied, you need not go ahead with the permission from the central government. Right? So if you refer to the part 1 of Schedule 5, as per this, a person shall be eligible to be appointed as a managerial personnel. When I say managerial personnel, I include a manager, a managing director, as well as the whole-time director. Right? So you can go ahead with appointing them without obtaining the approval of the central government. But for that, there are certain conditions that are prescribed in the part 1 of Schedule 5 that needs to be fulfilled. So there are 5 conditions laid down. If these conditions are fulfilled, you need not go ahead to take a permission from the central government, right? You skip that process. But if these 5 are not fulfilled and still you want to appoint somebody as a managerial personnel in your company, you need to seek permission from the central government. So let us see what those 5 requirements are. Number 1, not imprisoned or fined. So when we say that the managerial personnel whom we are proposing to appoint, he should neither be imprisoned nor be fined. But for that fine, there is a limit given that is beyond rupees 1000 for some specified defaults. So when we say not imprisoned and not fined, so that person whom you are taking up should not have been sentenced for imprisonment for any period of time, not even a single day. So if the court sentenced imprisonment to any individual for even a single day, that person will not be eligible over here. Or if he was not imprisoned but there was a fine that was attached to him and that fine exceeded rupees 1000, then also that person will not be qualified for this. But understand, fine exceeding 1000, maybe I break a traffic rule and I'm fined rupees 2000. Do you think I'll not be eligible to be appointed as a managerial person for that? The answer is no, because that is not relevant in my situation. I could have at any point of time broken a traffic rule. That is general. I may not be carrying my license or my insurance must have expired. That's possible. But does that mean that I'll not be taken up as a managerial personnel? The answer is no. So what this schedule says, part 1 says that it should be a conviction for an offense under certain acts. And if you go ahead to understand what acts they have specified, right, then you see the majority of the acts are some acts that we have been studying. Like you pick up the Central Excise Act and Salt Act, the Companies Act, the Security Contract Regulation Act, the Competition Act, the FEMA Act, Foreign Exchange Management Act, SARFAESI, the Securities and Exchange Board of India, the Prevention of Money Laundering, Foreign Trade, right? These acts are something we have been studying. Apart from that also, like if you go back to your group 2, right, taxes. So the Wealth Tax Act, Income Tax Act, Custom Act, the Essential Commodity Act, Prevention of Food Adulteration Act. So these are certain acts under which if you have ever been punished, right, if you have ever been convicted for an imprisonment for any period or for a fine over 1000 rupees, then you will not be eligible to be appointed as a managerial personnel. But even then, if you desire to appoint such person as a managerial personnel, you will have to seek an approval from the central government for the same, right? So any person who is convicted for an offense under any of the acts that I have just mentioned, right, then he can also be appointed as a managerial person, but with an approval of central government. If central government says, okay, he's allowed, that means he will no more be disqualified on these criterias. But after appointment, if these disqualifications attract again, then that person will be disqualified. Then he'll have to vacate, right? So earlier, now what happened is few years back, maybe one person, maybe I was convicted under say the Foreign Exchange Management Act, the FEMA Act. So now I would be disqualified, but the company that was deciding to take me as a managerial persona, that company spoke to the central government, seeked its permission, and the central government allowed. But again, 3 months down the line, I went under certain default under the Competition Act. Now what happens? I attract that disqualification again because once the central government has allowed me, that was to be done or that knocked off my prior guilt. But now further if I am involved into something, then that old permission will not compensate for the same, right? And I'll have to vacate the office. So that is what part 1 of schedule 5 wants to say, right? Always remember, it is not for any other imprisonment or conviction. There are certain acts that have been specified. You don't need to mug up all the acts for your examination purpose, but you need to simply have a logic. So when we are dealing with Companies Act, Competition Act, Income Tax Act and all these are acts that are related to a company, that are related to the operations of the company, right? So if I have been a defaulter with any of the operation, then obviously I'm not a eligible person. I'm not a suitable person to be holding a managerial position, right? Okay. Next, if the person is not detained. Now, when I talk about detention, so detention has to be under a specific act. When we talk about detention, it's basically that you should not be detained for any period under the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. So you should not be misappropriating any foreign currencies, foreign exchange, and you should not be involved in any smuggling. For any of these two things, if you are detained, then you can never be a managerial personnel without the approval of central government again, right? Maybe you have been trapped sometime and there was some convictions or some detention attached to you and then you were released, right? So now what the central government can do, the central government can look into the matter and allow. So if central government allows, you can still be appointed as a managerial personnel, but again the same thing. If you have been appointed and then further any of these detention attracts to you, you become disqualified again, right? It's the same thing that carries on even over here. Okay with that? Next, the age between 21 to 70, it is again the same thing. So even the schedule 5 says that your age has to be somewhere between 21 to 70. But again, a person who has attained the age of 70 years already, he may also be appointed as a managerial person. And for this, you don't need a central government approval, right? Even if the members in the general meeting, they pass a special resolution, you can be appointed even after the age of 70. They have to just justify, right? Why do you want to take up a person who has already attained the age of 70? It's huge. We don't even know if you're going to live that long. And that kind of an old age man, you put him into the managerial position, right? It's a little discomforting. But again, if there is a special resolution passed, they all think that no, this man is capable enough to handle, then it's okay. Law always keeps the route open, right? Next, ceiling on drawl of remuneration. Yes, and there has to be a ceiling on the amount of remuneration you draw, right? So what should be that ceiling? So see, when we talk about ceiling, there has been certain ceiling that has been specified in the part 2 of schedule 5. So we will obviously will respect that part. So what happens is where a person who is a managerial person, in more than one company, right? Then you are allowed to draw remuneration from one or more companies subject to the ceiling that has been provided in section 5 of part 2 of schedule 5. So you can draw remuneration from one or both the companies provided that the total remuneration that you draw, right, from both the companies should not exceed the higher maximum limit which you are allowed to draw from any one of those companies as per section 5 part 2 of schedule 5. Now there's something you need to understand in this. See, when we talk about ceiling, I may be a managerial person in one or more than one companies. I cannot be a whole-time director in two companies, right? I can be a managerial person in one company, plus I can be holding any position in some other company as well. So what part 2 of schedule 5 says is that it's okay for me to draw higher remuneration. Like, for example, if the limit is 60 lakhs per annum and this company pays me only 30 lakhs. So it's okay for me to be associated with some other company as well and earn a maximum of 30 lakhs more, not more than that. If you again get back to what I said, then you can collect remuneration from both the companies provided that the total remuneration drawn from more than one company basically that does not exceed the higher maximum limit admissible from any of the companies. So in one company the higher maximum limit is 40 lakhs, the other company the higher maximum limit is 60 lakhs. So I may be receiving 40 lakhs from one, so that doesn't mean in the other company I can get total 60 lakhs. That is one CR. No. If I am already receiving 40 lakhs from some place, right, then the maximum admissible amount that I am yet to receive is just 20 lakhs. So that is the ceiling limit and that will be my ceiling limit as well. So that is just to discourage. Please do not go to multiple companies. Stick to one, build it, yeah. Come on. Right? There's the funda behind. So highest limit is already given. Either you take it from one company or take it from multiple company. We don't care. That is the situation. The last part is that the person is supposed to be a resident in India. When I say he must be a resident in India, then what is resident in India for this purpose? Being a resident has different meaning, right? You have been studying your income tax also, right? Your direct and indirect taxes. So residents have different meaning in different sections over there. So over here also when we talk about being a resident in India as per Schedule 5, the meaning changes. So the resident in India would include a person who has been staying in India for a continuous period of not less than 12 months. So instead of 182 days or something that has been defined in your income tax act, if you remember, right? Capital gain and stuff. We are not talking about 182 days. We are not talking about any number of days here. We are specifically talking about 12 months. That means either 12 months or more than that. And from when? That 12 months should be calculated immediately preceding the date of his appointment as a managerial person. Plus, they also say that if the person has come to stay in India for taking any employment in India or for carrying on any business or vocation in India, then they are allowed. So when we talk about being resident, so either you have to be in India for a period of more than 12 months, not less than 12 months preceding the date of your appointment, and who has come to stay in India for taking up an employment or carrying on a business or vocation in India. So that is the definition of resident in India as per the part 1 of schedule 5. So remember, this is law and taxation that you are dealing with. So same word may have different interpretation and different meaning at different places, different definitions as well. So that is about the eligibility requirement. Now we'll have to hop on to the remuneration part, but I think I'll break the lecture over here and we'll start afresh the remuneration from the next lecture, right? Because that is gonna take a couple of lectures, I guess, maybe 2 or maybe 3 to the max. So we'll be discussing the remuneration part in the next lecture. That's all for the day. I'll see you guys back in the next lecture. Until then, this is Abhinay Gupta signing off. Thank you and bye-bye.